the whole landscape.
Yeah.
You all set, Cheryl?
You can go ahead and go.
Okay. All right, let's go ahead and get started. I'm very happy to welcome my colleague, Professor Jonathan Feingold from Boston University School of Law, to talk to us today. His scholarship looks at the relationship between race, law, and the mind sciences. Lately, he's looked at why various American legal regimes, including equal protection doctrine, function to reinforce and reproduce racial hierarchy. And he's published articles in the California Law Review, Northwestern University Law Review, Utah Law Review, and Temple Law Review. And Professor Feingold and I also co-authored an amicus brief in the two cases before the U.S. Supreme Court that deal with affirmative action, SFFA v. Harvard and SFFA v. University of North Carolina, Chapel Hill. So we had an intense working period this summer trying to get that done. So without further ado, I'll just turn it over to Professor Feingold.
And can the Zoom people hear me and see me well enough?
Yeah, I think so.
Cool, all right, well,
Yeah.
Cheryl, let me know if not. Thank you, everyone, for having me. A special thanks to Vinay for bringing me out, and to Cheryl for just making the logistics so easy. And I really need to sing Vinay's praises for the work on that brief. It was this moment in the summer when there seemed to be a little gap in the record, and there was no way I was going to do that by myself. And Vinay said yes, and helped actually get us there. And so that was a really great project. What I'm going to talk about today is really sort of the early stages of what I see as my next big project. And part of it is sort of foreseeing where the Supreme Court is going to go in a number of cases, and trying to really distill what that means. It is not a positive outlook from my perspective, but I think descriptively, it might be right. Which I guess is all to say, I'm really interested in your comments and reactions and questions. And so I look forward to that part of the conversation. As I get this back on. So my claim, let's start with my claim. Racial diversity is unconstitutional. Now I say this as someone who spent 4 years working in UCLA's Office of Equity, Diversity, and Inclusion, someone who cares deeply about racial diversity. So I certainly don't mean to suggest that normatively racial diversity should be unconstitutional, or aims that intend to promote racial diversity are. And I also am not saying that right now is a matter of doctrine, it is. But if you see the court, if you see some cases in the horizon, I actually think this is where we're headed. And so to be clear, I don't mean to suggest that the Constitution says that racial diversity is unconstitutional, but we have a Supreme Court that gets to say what the Constitution says. And so according to that court, I think this is where we're headed. So how might we get there? Well, we can start with the law. Anyone who has taken first-year common law knows that we have two tracks for analyzing claims that involve either racial classifications on the one hand, or essentially the rest of the world on the other. By racial classifications, I mean any policy that permits a decision maker to account for the racial identity of an individual applicant. By everything else, I mean everything else. And so we can break this down a little bit. So track one would involve racial classifications, the cases that Harvard and UNC are now defendants in right now. And the presumption now is that affirmative action, a term I'm using, I'm conflating right now with racial classification, presumptively unconstitutional. The burden automatically shifts to the defendant university, but there is a way out. Right now, under existing law, racial diversity, we know, we learned this in first-year common law, is a compelling interest. So that's track one. This is just the law. Track two is what I'm referring to as alternative action. So it's a term that Kim Ford-Mazrui offered about 20 years ago, just to try to capture all the various non-racial classifications that can be used to try to promote the ends that affirmative action is generally understood as wanting. Presumption, totally good. Diversity, not even really relevant to the conversation because there's so much deference given in these cases. So that's the law. But the law is shifting. And so as probably maybe everyone in the room knows, there's two Supreme Court pending cases now in which Harvard and UNC are defendants defending their existing race-conscious admission policies. Vinay, I think, is a slightly more optimistic potential prediction than I do. But I think, we know where we're headed. And the reason why these cases are on track, one, is because of this part of the holistic process. So this is a visualization that Harvard created to try to describe how its process works. And the reason why Harvard is in track one is because down here in the bottom left, we know that they employ what the court would refer to as a racial classification. Now, of course, that's a term that is underdefined often. And again, the law. If the Supreme Court today were the Supreme Court as it was in 2016, the Supreme Court that in Fisher reminded us, oh, Grutter actually answered this question. Racial diversity is a constitutionally compelling interest. These are holistic programs and they're narrowly tailored. Harvard and UNC would win. But these cases would not be at the Supreme Court if Harvard and UNC were going to win. And the doctrinal shift that I think we will see is focused on diversity here. Supreme Court is going to say, my prediction, 5 justices overturn Grutter. And even if they do not do that as a formal matter, I think as a functional matter, that is what's going to happen. So what that will essentially mean is schools like UNC, Harvard, University of New Mexico, wherever you are, if you're currently considering, even in the most infinitesimal way, racial identity of individual students, you got to stop, unless you want to engage in some sort of, Supreme Court civil disobedience, which you could do. Your general counsel is probably going to advise you not to. But so then you might say, all right, well, we do as an institution value racial diversity. It's actually integral to our mission. And this tool that we had that was helping us get there, that was in every sort of way modest, slight intervention, meant to just buffer against all the ways in which race is already sort of informing this process. What might we do? If you're Harvard, you might look at that little ellipsis in the bottom right-hand corner. So you might ask, well, what is in this little ellipsis? Harvard created this visualization to tell us what they're taking into account. And there are 3 little dots. Turns out those 3 little dots do a lot of work. They include legacy preferences, which we now know from the litigation, if we listen to the expert witness for the plaintiff suing Harvard, that in a recent 5-year period, 1/3 of Harvard's white admins, like 1,600 students, if I'm recalling correctly, would not have been admitted if you were not taking into account that legacy bonus. Their metrics, they were mismatched to Harvard based on their, the metrics that we tend to think of as the right metrics. And so if you're Harvard, all right, no one likes us because of legacy. No, we do care about racial diversity. So if you read any of my work, you know that I think Harvard doesn't care about racial diversity as much as a whole lot of other things that it cares about. You might say, okay, what are we going to do? We'll cut that. We'll get rid of legacy. And my guess is folks will weigh in and they'll say, is this actually going to be effective in producing racial diversity, or are those spots just going to go to other students who already enjoy a ton of, social racial advantage? But not many people, some people, Vinay would be like, raise his hand and be like, yeah, but in 3 years, Supreme Court's might take issue with that. And that's true. But the law right now is that is precisely the sort of policy intervention. It's like institutional change that on the books is completely permissible. There's nothing about it that should be problematic. In fact, the Supreme Court, even conservative justices like Justice Thomas, Justice Scalia, have said in track 1 affirmative action cases, well, if you want to get to that end, just use the race neutral alternative. So getting rid of legacy is a race neutral alternative. Here's the but. There's all these cases right now working their way up through district and appellate courts in which some of the country's most competitive magnet schools, public high schools that have a specific admissions process, they made tweaks all around 2020 to try to make a process more racially inclusive, and they've all been sued for doing so. Almost, if not all, represented by a specific legal foundation, conservative, right-wing, legal outfit that, done a lot of work that is, from my perspective, sort of anti-equality oriented. For purposes of now, I just want to talk a little bit about Thomas Jefferson, which is one of the schools that essentially did the race neutral alternatives that the Supreme Court has been saying, like, that's the way to go. And you might not know TJ. You probably know US News World Report holds a lot of sway in a lot of ways that probably shouldn't. According to them, TJ is super good. Thomas Jefferson was #1, at least as what Google told me yesterday. And their score, this pointer work, you can't really see it, 100 out of 100. That's really impressive. No one's 100 out of 100. It turns out TJ's not actually 100 out of 100, and there's something problematic about US News and World, because in the summer of 2020, when we were all sort of sucked into these conversations about racism, anti-racism, racial justice, that was happening. I imagine it was happening here. I know that at BU that summer, the faculty were just trying to work through, what does that mean for us? What are the things that we're doing that are reproducing privilege in ways that we don't want to? What are steps that we can take to make this a more inclusive institution? That's not excluding people who should be here, but for all sorts of reasons don't get here. Those conversations are happening at TJ. This is Anne Bowden-Tabus, who is the TJ principal then, June 2020, TJ principal now. And this was a letter that she wrote to the TJ community that summer. I wouldn't normally read, but I want to make sure everyone can see the text. And what she said, among other things, that our school is a rich tapestry of heritages. However, we don't reflect the racial composition of the district. Our 32 Black students and 47 Hispanic students fill 3 classrooms. But if our demographics actually represented the district, we'd have 100 Black and 460 Hispanic students, respectively, which would be a 5-fold and a 10-fold increase. Then she posed a number of rhetorical questions, including, do the admissions outcomes affirm our belief that we as an institution are accessible to all students or talented in our STEM focused endeavors, irrespective of their personal circumstance? And also in this year, 2020, the number of Black students admitted was so low that it couldn't be reported due to anonymity concerns. And so, backdrop of that summer of just global unrest, it led to some changes. All changes facially race neutral. So the left column that you see here, that's sort of standard features of the pre-existing policy. Admissions to TJ. And TJ is a selective magnet school that people from all over the world try to get into. And some of its features was that it required a minimum 3 PA GPA. You had to pay a $100 application fee. If you satisfied those top 2 requirements, plus some other requirements, like you were in the 8th grade, you lived in a feeder school district, then you would take a series of standardized tests. If you did well enough on the first series, then you might take another. And then everyone who moved through was considered through a holistic review process. So that's the prior policy. And then after a lot of work locally at TJ, in part due to efforts from the then governor's office in Virginia that was trying to put pressure on local schools to really interrogate whether their policies were locking out students, not because of their individual merit, if you want to sort of use the merit lingo, but because of the broader circumstance. And so these are some changes, some of which actually you could argue ramped up sort of the academic requirements, including that you had to have a minimum of 3.5 GPA. You also had to have had taken a certain number of specific honors courses, but there was no application fee. And it turns out that a lot of students just did not apply because of the application fee. And if you met all of those above, you continued on, but there were no longer standardized tests. They just eliminated it. Like, this is not actually testing the thing that we want to be testing. Or it is in ways that are locking out certain folks. And then there was a holistic review. And so the holistic review was taking into account everything, including these new experience factors, which could include an individual student's socioeconomic status, whether they were an English language learner, whether they had an IEP for students with disabilities, and whether they came from a high school that was historically underrepresented in TJ. And then there was essentially a 1.5% plan. So if you're familiar with 10% plans that became popular, University of Texas and other places in the mid-90s, after it looked like affirmative action was going away, similar sort of policy here where every feeder middle school essentially was allotted 1.5% of the total slots. And so their top students would go, and then there was about 100 slots left after that, where sort of this process would run through. If you're the general counsel for TJ, and you are not concerned about the Supreme Court turning what I call inequality law further on its head, this should give you no pause. But also, it was effective. So if you see, and again, I'll read this out a little bit just in case it's hard to see. So the left-hand column, which is the racial demographic, the group, then their overall percentage in the districts, the second column. Third column is their relative representation in the sort of so 2020, so before the changes. And then the right-hand column is their representation in TJ after the changes. And so the things that stand out is, for instance, Latinx students, 27% of the district, only 2% of students entering in 2020. Black students, 10% and only 1.72%. It's also maybe interesting that white students are almost 40%, but less than 20% of admits. And then that 2021 cycle saw meaningful jumps for both Black, Latinx students, sort of a little bit of a dip for Asian Americans, and white sort of increase a little bit. And so this, I think of the casual observer, it's like, oh yeah, you made some tweaks and your school is still like far from, like what we think of as some crude racial balancing. Certainly not proportional. You might still think that there's more work to be done, but it's moving closer. So again, back to the law. These sorts of policies in the magnet schools, the public high schools, are not racial classifications. So they should be running along this second track, meaning that a lot of deference to the institution, and that diversity, if anything, it's a good thing. And so the question is then, how does Pacific Legal, that's bringing all of these suits and recognizes that it has to move through track 2, what is their legal theory? And if you sort of scan the law reviews out there from the past 20 years, there's a couple that suggest, well, if you want to make equal anti-discrimination law in the constitutional context really coherent, like go super hard into color blindness, then maybe any racial motive, including like the desire to integrate an institution, maybe that's constitutionally suspect. We've never gotten there, in part because that's just so untenable to suggest that the Constitution is hostile to efforts to integrate institutions. But what does TJ or what does Pacific Legal have to say? So they know that they've got to prove an impermissible racial motive, and they have to show some sort of disparate impact. And so on racial motive, and I'm happy to sort of dig into this more deeply in a Q&A, but essentially what they are saying is that any attempt to alter the existing composition, racial composition of an institutional body is an impermissible racial motive, which means effectively that the desire to become more racially diverse is an impermissible racial motive, and the desire to close gaps is an impermissible racial motive. Again, we can talk more about how that squares with existing doctrine, whether there's like sort of legitimate space to maneuver. It is worth noting that, so these cases have made their way up to, there's at least 5 or 6 out there right now. One, Reagan appointed, for whatever that's worth, a district judge in the TJ case found for the plaintiffs, essentially adopting their rationale. Fourth Circuit there, First Circuit in the Boston Latin cases, other circuits have essentially said no, like in part because it just seems so antithetical to common sense to think that these sorts of policies are unconstitutional. But the move on the part of the plaintiffs is to suggest that any attempt to alter composition is an impermissible racial motive. And the sort of facts that they point to are statements like this. Statements that the district fails to resemble the racial composition, or that the school fails to resemble the racial composition of the district. And then what the plaintiffs say is like, this is just racial balancing. And the Supreme Court has said that that's patently unconstitutional. And look, they're not even hiding it. What about disparate impact? The disparate impact here could be measured in a few different ways. Disparate impact could be, well, what is the sort of relative rates of admission? We just take sort of the total number of applicants of different sort of racial groups and what's their rate of admission. That's one way to think about it. One is just to see, well, who's admitted relative to your overall demographics in the district. You maybe narrow it based on, well, who met those initial sort of qualifications and went through. Plaintiffs are saying it's any percentage decline from one year to another. Jonathan Glader, who's an education scholar at Berkeley, I believe now, recently sort of wrote an essay on this. And what he was saying is like, look, the claim is it's a right to the status quo, that you're measuring disparate impact based on movement from the status quo. Now, if that happens to be a status quo that is, you know, infused with all the exclusionary forces that obviously are, you know, occurring in these cases, from the plaintiff's perspective, like that's, you know, that's a feature, not a bug. From Professor Glader's perspective, like we should be uncomfortable with that. It's like, okay, so what's the evidence that the plaintiffs point to? And they look at this drop. You had a 16–17% drop from the year before to the year after. So according to the plaintiffs, that's sufficient to constitute the sort of disparate impact that could enable you to satisfy this prima facie showing. Again, the district court bought it. District court didn't do, to be fair, a whole lot of analysis to sort of articulate reasoning. And in a concurrence in the Fourth Circuit's sort of overturning of that, concurring judge who offered a lot of thinking, like, well, that can't be the relative baseline. That can't be how you measure it. But three current Supreme Court justices, so Fourth Circuit overturns, finding for TJ, then Pacific Legal Appeals to the Supreme Court, and this is all about just getting an injunction. Supreme Court denies cert, but three justices, I believe Thomas Alito and Gorsuch, they dissented, which seems to be previewing sympathy to the plaintiff's arguments. So this is the law. This isn't even the law now. This is what I think the law is going to be in June after we get the rulings back from the Supreme Court in the SFFA cases. But then were the Supreme Court to adopt the plaintiff's reasoning in these alternative action cases, we don't know for sure whether that's the case, but it's hard to think that they don't have at least four, arguably five justices who are sympathetic. Means that racial diversity itself becomes suspect. Because what it means that is if your student body reflects the racial demographics of the geographic region you pull from, that itself is going to be probative of this impermissible racial intent, which means that the sort of work that TJ did, sort of work that Harvard, UNC, BU is currently contemplating about how to not have demographics fall off a cliff the way that happened in California after Prop 209. All those efforts are actually going to be presumptively unconstitutional again if a Supreme Court were to adopt these arguments. That means we no longer have two tracks. For decades, the Supreme Court has been so clear that we should have two tracks because there's something particularly bad about racial classifications that do not travel into the non-racial classification space. But this is the doctrine we're looking at. But only for projects that are intended to promote equality. There's not going to be a track for racial disparities in police violence. There's not going to be a single track for racial disparities in health outcomes, exposure to pollutants or toxins. There's going to be a single track, but it's only for efforts to promote racial equality. So I'm going to stop there. Again, this is a prediction that I hope never comes true. But I think it is really worth seeing where organized sort of, I think is very fair to describe as sort of right-wing sort of law firm think tank coalitions are trying to go, where on the one hand, in the Supreme Court cases right now, are saying, well, Harvard, UNC, if you want diversity, just use race-neutral alternatives. We're at the exact same time saying, oh, those racial-neutral alternatives, also not okay. So I'll stop there. Thank you, and I'm really excited to, just get into the conversation.
I'll start. I guess I've always viewed the racial intent to give people opportunities to have equality. That's not the critical factor. To me, it is the way you get there, the method. And if you have quotas, if you have mechanisms that essentially target certain groups, that's going to be racial groups, that's going to be unconstitutional. That'll be denial of equal protection, because equal protection is just say each one is everyone, black, white, Hispanic, whatever, should be treated equally. And if everyone is treated equally, in terms of the criteria that are used, without, and I think what the Supreme Court has basically said, you just can't make race one of those, but then you are treating people under equal protection clause unequally. So I always thought it was the method. I think the court will continue to make that kind of distinction and say, so long as you want to have racial diversity, it's okay, so long as you don't use a mechanism or method that discriminates against a particular group.
So I think it's a really good question, and sort of your description that I heard, I think sort of accurately captures how the majority of the Supreme Court has thought about efforts to promote racial equality, you could say, where the focus has been on the mechanism. The language has been all about racial classification, sort of tethered to this notion. I don't necessarily agree with it, but this notion that we're all individuals. 14th Amendment cares about the individual. To the extent you start taking race into account, that's somehow contravening this commitment to quote unquote individual review. And I think that accurately captures how folks like Scalia talk about this. It's like Croson, standard first-year common law case. In Croson, Scalia raises those points. 14th Amendment's all about the person. Racial classifications problematic because of that. And so Richmond, you want to deal with this, focus on some other things. But even there, Justice Scalia seems to be suggesting that the problem is the mechanism, that there's something special about racial classifications. And we could talk more about, the different sort of reasons why the court has said racial classifications deserve more scrutiny than race-neutral alternatives. One thing that's interesting, and so then the question is, okay, well, is the Supreme Court going to sort of scrap that? That's my prediction. Is that consistent with what the right-wing justices have been saying? No, unless it's been about interfering with efforts to remedy all the ways in which race, functions to entrench, reproduce hierarchy in the country. In that sense, you do, like, it is a linear thread. And the last thing that I'll just mention on this is, well, that's really interesting. The entities backing the litigation against the magnet schools. They're sort of their think tank counterparts. And even in some of the briefing, sort of traffic in this pretty sort of pejorative rhetoric with respect to equity. They say, it's not about equity, it's about equality, where equity is a concern with outcomes, where equality is a concern that everyone just like gets judged on their merits. The claims against TJ are rehearsing equity type theories. Because when you're saying, because the problem here is not that any student is held to a different standard. All students are held to precisely the same standard. In that they have to take the same classes. They have to meet those same requirements. They have to have the same 3.5 GPA. And the harm is a group-based harm. It's that the group has suffered some decline in their overall representation. And so there's these like weird dynamics happening here. Where on the one hand, you can see these cases as a natural extension of your colorblind hostility to racial remedies, but it's also a total U-turn from some of the sort of theoretical sort of, or just conceptual underpinnings that ostensibly have anchored colorblindness.
Thank you so much, Professor Feingold, which is very fascinating, and I like the charts. It was very clean to think about it and to put things in its spaces. I'm thinking about something you said, which is, did the Constitution ever mean for us to have this conversation and bring in race? And on many levels, there are so many scholars that say, yes, the Constitution had race written all into it. It had racial classification. Every standard within it is playing this strange game of taboo. How many ways can we talk about race and not say the word race? And so I do find that to be an interesting thing in the back of my head of what will be these next proxies. We've seen it happen in so many other places. You can't discriminate against because of race, but then we might discriminate against because one's behaviors seem to be uncouth, or one is not a good team player, and there becomes all these side words that are used. How much do you think that will now go into institutions' attempts? Will they find other kinds of mechanisms? If racial diversity is not okay, what kind of strange game of taboo will they play to still try and address what this principal did point out is there's some strange things happening in the system.
So let me try to answer that.
I said way too many things, sorry.
No. And also say, please feel to call me John. Like I definitely don't need the professor in front of it. Yeah, let me sort of try to take this from the side a little bit. But if it's not responsive, let me know. So Sonia Starr is a professor at University of Chicago, has one of what I've seen is like the first sort of big sort of dives into this litigation that's forthcoming at Stanford next year. And one thing that she says is, well, is it possible that this being a term with less emphasis on racial classifications, but more like this much broader conceptualization of racial motive that captures a lot of stuff, could that actually open the door to capture a lot of the sorts of behavior or conduct that an intent-based anti-discrimination law hasn't been able to catch? Or to put differently, from the left, the critique of anti-discrimination law or disparate impact theory is that when the court gutted it with Washington v. Davis, it essentially insulated a whole host of policies that reproduce inequality, including a lot of policy, like a lot of sorts of conduct that seem to have been like pretty motivated to reproduce and entrench racial exclusion. And so it's like, okay, well, if the court is going to be consistent with that, so like if you think like Trump v. Hawaii, like a case in which the president of the United States was pretty open that there was sort of like religious animus sort of underlying it, but the court there's like, no, you can't take that into account, like for different reasons. In that case, if you're going to apply that consistent here, then the statement of principle, it's like, well, that doesn't matter, like just some offhand statement. And so then the question is, okay, well, could these magnet tool cases be a corrective for Trump v. Hawaii that actually makes it easier to challenge the pretextual sort of racial motives that folks on the left would want to be able to challenge? I don't think so. Not because that wouldn't be doctrinally consistent, but because that's not what the point is. But yes, but that should be happening. If we're in this game of trying to realize sort of coherent, consistent doctrine. Is that responsive?
Yeah, thank you.
And Renee, should I be calling our folks or?
You can call them folks, and I mean, I got it.
Okay,
We can talk later.
I mean, I'm sorry, I have kind of a cheeky question.
sure.
And it's, I think it might be, I don't know who's doing admissions this year, but if we're gonna be looking at status quo, is this kind of our last chance to get our numbers up as high as possible? So that, I mean, we've really worked hard and I think, diversity is really important to us. We've made progress in some areas, not so much in others, but if what's gonna happen is we're gonna take where we are now at the time of this decision as the status quo. Is this the year to sort of not care so much about our other indicators that may prevent us from having a more racially diverse class?
So my sense is that I'm always going to give an answer that's different than your general counsel on all of these issues. But I think
Are you supposed to here?
oh no, I'm being,
I'm joking.
yeah, oh, okay.
Joking.
Yeah, so I'm playful there. I was on a panel with BU's, one of representatives from BU's Office of Campus Council talking to the admissions team. And we made very clear up front that we had different roles.
Yeah.
So I think that every institution should be really cognizant of what the future portends with respect to the ways in which all sorts of efforts that are both constitutionally sound, morally sound, pedagogically sound, except for the fact that we have a Supreme Court that has embraced some pretty radical viewpoints. Because what the Supreme Court would be saying is that the desegregation, all the desegregation mechanisms were unconstitutional. And that's what they would be saying. But I think it's important to be mindful of it. I think it also means that it's another time to just make sure that institutionally we're just being sophisticated when we're talking about things like diversity. And inclusion, why is it that we want this thing? And it's not just because we want to sort of reflect the demographic of New Mexico, if that's sort of the thinking, but the question is, well, why wouldn't we? Shouldn't a fair and equitable process reflect the demographics of New Mexico? And so then the question, I think, can really turn on to interrogating, well, what is it about a particular process or conceptions of merit or the things that we're considering that are locking out certain students, so that the motive is, again, this is just in a very sort of defensive posture, trying to do as much as possible to prevent Pacific Legal from saying you're engaging in the wrong sort of racial motive. It's not about racial motive, it's about just trying to increase the quality of our student body by interrogating all the ways in which our current system is actually locking up people who should be here, or different things. Obviously it'll be a local conversation, but I think the point I'm trying to make is that it makes sense not to simply say we want diversity for diversity's sake, but to make clear why. And I think even without these cases, it's important to make clear why, in part so that diversity isn't disconnected from racism or from concerns about how racism is embedded in society more broadly and within a particular institution. But I think that would actually be the case even were the Supreme Court to uphold Grutter. I think it would still be really important to have a clear institutional answer for why it is we care about diversity. And I think part of that has to center students from groups that are historically excluded, and recognizing that when they continue to be on campus, it actually denies them the full and equal enjoyment of the university experience due to the various sort of institutional dynamics that can manifest when you are severely underrepresented. But I'll stop there. Good, any arguments? Oh.
Sort of a follow-up question. Suppose an educational system like in Texas decides that they're no longer going to admit students at any of the UT system schools except through the top, let's say, 2% of every high school in the state. So there's basically no admissions decision except did you graduate in the top 2% of your high school class? And so you've got all these small towns all over Texas. Each one of those schools can have presumably the top 2% to get into any of the UT schools. And you can define it, I guess, or justify it on the two bases. One is you have a motive of increasing racial diversity because you're going to see a lot of Hispanic and African American in certain pockets of a lot of the African Americans in the cities like Houston, a lot of Hispanics and down along Rio Grande, and or you could say that the motive is to increase the geographical diversity of the student body, not race, it's geographical diversity. Does it make a difference which one of those you choose?
So really,
And you think that would be upheld by the Supreme Court if in fact you show that now UT system goes down from, let's say, 65% to 35% white enrollment in these schools?
so I guess a couple of things. One, empirically, I think it is a really open-ended question whether sort of geographic-based plans actually are able to realize the sort of robust sorts of diversity that a lot of people want. I know, I don't think in Texas it was as effective as Texas expected it would be. One reason why Texas sort of went away from it when it was able to, and also California, you sort of see the geographic-based plans for various reasons not be as effective as you would think. But so here's the really interesting question. It's like, so if you are the sort of savvy campus council, you're going to say, and your only goal is to avoid litigation. Never say the word race again. Never say the word diversity again. I think that would be deeply problematic, particularly for institutions where their mission, like so UCLA, I spent about 10 years there in different capacities. It's a state school. Part of the institutional mission is to represent California in different sorts of ways. And so to engage in a sort of self-censorship purely to avoid some sort of legal exposure, I don't think is the right thing to do. But if your only game in town is avoiding legal risk, then yeah, you never uttered the wrong words. But then the question becomes, well, what is the evidence that a Supreme Court that is hostile to efforts to promote diversity will consider sufficient to satisfy that unlawful racial motive? And my instinct is that the Supreme Court would say, or at least some justices, certainly Pacific Legal, well, the university is only saying they want geographic diversity because they know they're not allowed to say they want racial diversity. And look, they have racial diversity, even more so than they did before the SFFA cases. And so what that means is that that's at least going to be sufficiently probative to sort of meet the prima facie case, which again, if you're like, well, clearly Supreme Court, you have not read the past 50 years of disparate impact type claims in which the court essentially does not accept anything as sufficient to satisfy that motive requirement. I'm guessing that there's going to be just a shift here and just sort of evidence-wise. But again, I'm speculating in a lot of different ways, but I think it's important to see how just like if you were to just follow this down, simply having a state school that represents the state population could be evidence of some constitutionally suspect motive.
I'm sorry, but that's kind of why I'm raising the question, because we're kind of close to that. And so what I guess if that was sort of the genesis for my question. But we've done it we've looked a lot and talked a lot about our reasons for this. We know it improves the quality of learning for everybody, including us. So so if we're already sort of close to that, do we really try really hard in these next couple of years in anticipation of that being the measure?
So I would say try really hard regardless of where the court is going, and just leaning into institutional values. But it's also maybe so like I'm a relatively junior professor, and maybe it's always been this way, but it feels sort of weird to be writing about this thing called, equal protection doctrine or constitutional law, where we know that right now facts don't really matter. At least not any, like, I don't know, none of the cases that like I've been seeing recently, which maybe is a little freeing for an institution that knows that even if it does precisely what the Supreme Court says it's supposed to do, that might not be enough, even if like the most originalist or like the strongest originalist viewpoint is one that suggests that, of course, institutions can try to promote racial diversity, that that's not going to matter. Like maybe there's a degree to which it's freeing, but like I certainly don't know how you teach con law right now. And other things. Vinay or Cheryl.
This is from Professor Elizabeth Illia. She's on Zoom. She said, thanks, John. This is fascinating. Following up on Sonia's point, if your prediction comes true, a school like TJ's best approach to advancing diversity seems like it might be to stop capturing race as a metric and instead looking to proxies like location of feeder school or zip codes. To the extent that schools and neighborhoods are segregated, it seems like these proxies would be effective. Could you speak to whether there would be harm to this approach?
So I guess two responses, and I maybe not super direct, which I apologize for. But one is, like, again, empirically, proxies often don't work as well as we think they do, which is one reason why it's really helpful to be able to just account for the racial identity of individual students. Like, among other things, if we are trying to account for how racism, again, like I'm using the term very broadly, we could talk more concretely about precisely what I mean, but if we recognize there's this thing called racism in the world and that it matters, like just administratively pretty straightforward to try to identify who has bared more of the brunt of it is just to ask, well, what is someone's racial identity? The second you go to proxies, it's just harder. California, Michigan are places where we've seen that. Did you want to jump in?
No, I'm waiting.
Okay. And so, but I think that certainly schools should just be trying to account for how different social factors that are not race per se are leading to outcomes that we find problematic. Because generally what that means is that there are certain people in certain communities just have access to particular sort of social capital that you need in order to get into these sort of elite places. And a side conversation that I'm not having here but should be had is maybe problematic that we spend so much time focusing on these 5 super elite institutions, whereas most of Fairfax County or Boston public schools are not actually like sufficiently well resourced. And I had another, the other sort of side sort of way to get at this is the questions that we're all asking right now, I think reflect a recognition that their current Supreme Court is hostile to projects of racial equality. In a way that for the past 50 years, the court has never been hostile to projects of racial inequality, because the court has always been so deferential in contexts in which there's been a facially neutral policy, where like all these little sort of like that would never even come close to being sufficient to just get past a 12b6 motion. And so I think it's just important to just recognize that one reason why like institutions are having to do this is because it's just another moment of just this doctrinal inconsistency where it's not even, it's a total, like we might call it like track 2, but it's not track 2, it's just track 1 by another name. I think Vinay's next, unless any students have questions.
Okay, so I got like 3 of them.
All right,
So I read the Thomas Jefferson District Court opinion and the Pacific Legal Foundation argument a little differently, that they had evidence of actual animus, not just an effect on racial composition, but the fact that, Asian American families were excluded. The work session where the decisions on changing the admissions policy were not open, that there were some anti-Asian American comments made. And the way the district court treated that was, so there is some impermissible racial animus motive. It's not the main thing, the main thing was diversity, but even having a little bit, any level of racial animus is enough to strike down the policy. So I'm wondering if there'll be a distinction between what you said is just kind of the motive to change the racial composition, distinguishing that from the evidence of actual racial animus in terms of like the anti-Asian American comments. So that's one part, would that be a doctrinal distinction? And was that the distinction we saw in the court in lifting the stay order, where the 6 justices, including the conservatives, sided with the liberals to keep the stay in place? Second question, just about admissions generally, any policy, any change in admissions policy can affect racial composition. So you have universities getting rid of the SAT or LSAT, that's going to affect racial composition. Legal challenges to all of that. Are there going to be legal challenges? Because what is it, Sweezy v. New Hampshire, one of the academic freedoms of a university is to determine its own student body composition. So universities have some autonomy, right? And schools have some autonomy, universities especially, to determine their admissions policies. And if any change in admissions policy can affect racial composition, does that mean they can't change any policy, or where's the limit there? So kind of wondering about that one. And then just your last point about proxies. You say how proxies don't work as well for race as we think they may do. But I'm going to confront this on Saturday at Drake, because I'm going up against someone who opposes affirmative action. He's going to say exactly the opposite. Whatever you think race contributes, that's a very bad proxy also. Race, diversity, certain experiences or viewpoints, that's stereotyping. So we flip that argument around. And how would you respond to that?
so, yeah, in no particular order, but taking the second one first. I think that what you could certainly see is the rise of a Supreme Court doctrine in which admissions changes that alter a student body in a way that becomes more racially representative, shifts the burden. And whether that means triggering strict scrutiny such that a compelling interest has to be shown, or whether it means that it is sort of a legitimate educational purpose, it's actually not clear when in the sort of magnitude cases, if the plaintiffs prove impermissible racial motive and disparate impact, what actually happens next? And arguably it's not strict scrutiny, but it's just a sort of burden shifting that's a lower burden, though the plaintiffs are saying it's strict scrutiny. But I think what could certainly happen is evidence, so change happens that leads to evidence in more racial diversity, I think could be presumptively, could at least maybe meet a prima facie showing. On the question about animus. So a couple quick thoughts now. One is, it is strategically rational for the Pacific Legal Foundation to be taking up cases in which the group that's harmed, or one of the group that's harmed, are Asian Americans, because it enables them to veil a project that is anti-equality. And by essentially offering a community of color that's been obviously racialized and subject to all forms of discrimination as the putative victim, because it just feels less inconsistent with how we traditionally think of anti-discrimination law. The other pieces, and I think that oftentimes in these cases, there is evidence of some sort of anti-Asian bias. SFFA, or not SFFA, essentially the same entity in all these cases. Pacific Legal is trying to highlight that in order to make the claim that the animus is underlying the purpose of the changes. I think based on the records, it's pretty clear that there is often some animus, even in sort of the selective indifference, just the lack of care for a particular community, that process has not been as good as possible in ways that can, I think, leave someone to feel unincluded in a particular way that is problematic in ways that folks on the left should be concerned about. But never would any of that evidence have been sufficient to satisfy impermissible racial animus in a disparate impact type case traditionally. And I don't think the record suggests that that animus is actually causally connected to the changes that were made. Though you could take, a broader view and be like, all right, in some way they were. But I still think it is a sort of a massive departure from doctrine to factually to uplift those facts as sufficient to make the finding of an impermissible racial motive. And like in the Boston case, there were text messages from some council members and a council member who was quite disrespectful to Asian Americans in a couple moments. But again, the Supreme Court has never suggested that sort of racial inhospitality, even if it's something that I think we should, name as like inappropriate in all sorts of ways, is legally suspect. Last question about so stereotyping, etc. We only have 1 minute left, so I'm gonna not provide we have no time left. This is like in class when I say there's 60 seconds left. I'm gonna ask a question, you can filibuster, and then I end up filibustering myself. But the last thing that I'll say is, and this I think gets to one of Sonia's questions from earlier. Historically, for the past 50 years, the Supreme Court has said that multiple right-wing justices, and even some moderate left-leaning justices have been somewhat amenable to this, that racial classifications deserve heightened scrutiny where facially neutral conduct doesn't, because there's something about racial classifications that make us queasy. Feels like we're stereotyping, we're essentializing, feel it's going to have some sort of stigmatic effect. It's going to, be balkanizing in different ways. I think there's really persuasive scholarship that responds to all of those. But I think that to the extent those concerns are what justified heightened scrutiny for racial classifications, it's just more evidence that heightened scrutiny would be inappropriate for these facially race neutral approaches, because they are free from the problems that the court has consistently said is what warrants heightened scrutiny. So I'll just leave it there as we're like backing my way out.
Thank you.
Thanks, everyone. Thanks, Cheryl.
Oh, you're welcome.
I'll see you guys later. Thank you so much.